It's been on the statute book for many years, and rather like the received wisdom that you don't get costs in an employment tribunal, and therefore many litigants don't pursue applications for costs. One also has tended to see a received wisdom that, yes, okay, interim relief applications exist, but you're not really going to succeed in them. But the interesting thing was, during the pandemic, there seemed to become a sudden fashion. Fashions come and go in employment. Dan is obviously going to start a fashion for adverse document applications in terms of disclosure. You heard it here first. It will become the Tat and Brown application, I dare say. And you saw a fashion during the pandemic of interim relief applications being made and starting to succeed. And following on from that, we started, in terms of our practices, seeing quite a few interim relief applications being made. Some of them made well, some of them made less well. And so certainly if you are appearing on behalf of a claimant and you've got a whistleblowing claim, certainly interim relief ought to be something that you're thinking about. Whether you will make it in the vast majority of cases, probably not, because as Grahame will discuss in due course, the threshold is pretty high. But bearing in mind the advantages that it provides for a claimant, if you succeed in an interim relief application, it's certainly something that we would very much encourage you to be thinking about. So in terms of the overview of the talk, just check I'm on the right side, I am. I'm going to talk to you about the qualification requirements for an interim relief application. I'm going to talk to you about procedure. Grahame is then going to hopefully rattle through, because we're running slightly behind, and we'll do our best to get you back towards where you ought to be in terms of timing, immediately winning over the entire audience, I dare say. Grahame's going to deal with the legal test. I'm going to deal with the effect of the continuation order. And then at that point, we're going to look at practical tips. And Grahame will assume the perspective of the claimant's representative. I will assume the perspective of the respondent's representative. So we'll be good cop, bad cop. It'll be for you to decide which of us indeed is the goodie or the baddie. But anyway, what we'll seek to do is come up with some practical suggestions as to how best these applications may be pursued. So first thing that we need to deal with is the qualification requirements. So obviously, as this is a talk about whistleblowing, you need to be bringing a whistleblowing claim, but recognise that there are other areas where interim relief applications can be pursued, for example, trades union dismissal cases. Interesting point to recognise, and this was particularly flowed from sort of the pandemic issues. If you are complaining about an automatically unfair dismissal, a health and safety dismissal under 101D or 101E, those in and of themselves are not claims which trigger the interim relief jurisdiction. But of course, the likelihood is that if you've said to your employer, I'm not going into that workplace because it's not safe, that is likely, or there's at least a significant chance that that will be sufficient to amount to a protected disclosure, because you're disclosing a failure in terms of health and safety, which therefore may trigger the jurisdiction. So I suppose the point would be, don't avoid or don't adopt too rigid a demarcation in terms of your thinking. Recognise that with a little bit of ingenuity, you may be able to shoehorn it into a whistleblowing claim. Next requirement is, because you are asserting an unfair dismissal complaint, it's only available to employees. And so for example, extended definitions of worker for all the purposes of whistleblowing don't matter. You've got to be an employee to bring this claim. No qualifying period of employment necessary. Recognise that if you have a case where there is a redundancy exercise and the contention is, well, one of the factors operating in my selection for redundancy is because I've made a protected disclosure, you're not going to be able to bring yourself within the interim relief jurisdiction, because you need to demonstrate that you need to demonstrate, subject to the relevant test, which Grahame will deal with, that the sole or principal reason for dismissal is whistleblowing. And if it's a redundancy exercise, the reason would be redundancy. And McConnell is authority for that proposition. Sorry. Okay, I've gone 1 too many. Yeah. So next thing, the procedure. So the moment you get an interim relief application, the clock is very, very much ticking. It is the closest you will get in the employment sphere to a High Court interim injunction. So the first thing that you've got to recognise is you've got 7 days from the effective date of termination to get the ET1 in. So immediately there's going to be an enormous focus in terms of preparation of the ET1, and it all has to be done PDQ. But recognise this, you can issue an interim relief application prior to the termination of employment. So if you're in the notice period and you want to seek interim relief, in fact, it's probably an excellent negotiating tool for reasons we'll come to in due course, you can properly lodge the application prior to the EDT. No requirement for an ACAS early conciliation certificate. So you don't have to have the pointless conversation with ACAS where you say, yes, we've issued a claim. No, we don't want to conciliate. And recognise that applies to the claim in toto. There's no need, if the interim relief application doesn't succeed, or indeed if it does, for you then to conciliate through ACAS. It's simply avoided in a case of interim relief. Tribunals are required under Section 128 to determine the application for interim relief as soon as is practicable. As I said, you will generally not have oral evidence. It is akin to an interim injunction in the High Court. And so this type of application is particularly suitable to being determined via CVP. So again, an advantage of this kind of application. Respondent has to be informed of the fact of the application, the date and time of the hearing, and provided with the ET1 not fewer than 7 days before the date of the interim relief application. Can be heard by a single judge sitting alone, and indeed, in my experience, they tend to be. It's conducted as a normal PH within rules 53 to 56. Interesting point. No requirement for a respondent to serve an ET3 prior to the interim relief application hearing. We'll come to, in the practical tips section, whether that is something that a respondent might or might not want to do. So then what about the question of an adjournment? Now, the reality is, in most cases, you're not going to want an adjournment if you're for the claimant, but you might if you're for the respondent, if there's some reason you want to get your ducks in a row. The case of Lunn dealt with a situation where the claimant had instructed a direct access counsel who had prepared the interim relief application, but when the application itself was listed, wasn't available. An adjournment was refused, and it was taken to the EAT as to whether the adjournment ought not to have been, or ought to have been granted. And essentially, the reasoning of the EAT, Her Honour Judge Eady, as she then was simply this. You need special circumstances in order to adjourn an interim relief application. You don't need exceptional circumstances, so that the power to adjourn continues to subsist, but the general expectation is, if you've issued an interim relief application, you get on with it, quite frankly. Hearing, as I said, summary hearing, no oral evidence. Rule 95 expressly provides that there will be no oral evidence absent an order from the tribunal. So very much the application is going to turn on the contents of competing witness statements, the pleadings, and the relevant documents that you are able to identify at the time of the interim relief application, which are likely to be limited. So, what is the approach that the tribunal is supposed to adopt? Well, Chaco says effectively the tribunal, and you'll see it's the second sentence, is then required to make as good an assessment as it is promptly able as to whether the claimant is likely or not to succeed in their claim. So a tribunal is not going to be resolving disputes of fact. It's going to say, here's argument, there's point A, here's what the claimant says, here's what the respondent says. On balance, I either think the threshold is met or not. What if you have a complicated application? Well, in Raja, a former regional employment judge in the, doesn't matter, former regional employment judge had effectively said, this is all a bit too complicated and there's really a bit too much here. So I'm just not going to deal with the interim relief application. That was held to be an error of law. As you'll see, what the EAT said was the employment judge should have required the parties to condense and distill the key points for her determination. What she wasn't entitled to do is say a plague on both your houses and then not decide the application at all. So that's a whistle-stop tour as promised through the procedural requirements. I'll hand you over to Grahame now, who's going to deal with the legal test.
So let's talk about the law. As Nick has already foreshadowed, the test is the claimant likely to win in his automatically unfair dismissal claim? But the question rightly on the tip of all of your tongues is, how likely is likely? And the honest answer to that is, your guess is as good as mine. But
it's definitely maybe, isn't it?
It's definitely maybe, possibly could be. What we know it doesn't mean is just 51% you're more likely to win than not. We know that. It's significantly higher than that, says Mr. Justice Underhill, as then in the Sarfraz case. And what's interesting about the Sarfraz case is that that was a case in which the claimant, in a story very familiar to all of you, I'm sure, brings lots of grievances. Of course, they're all protected disclosures. Of course, actually, the reality is he's somebody who can't accept any form of criticism, and therefore everything must be somebody else's fault and must be some sort of conspiracy. The employment judge in that case got it wrong because, as we'll come on to discuss in a moment, he omitted to deal with one part of the test. But what that meant was that it was Mr. Justice Underhill himself in the EAT who had to decide how likely it was that the claimant would have had a reasonable belief in the truth of what he was saying in his disclosures. And Mr. Justice Underhill says, well, he's made some submissions before me, and I got the impression that he wasn't somebody who could accept criticism in a proportionate way. So I don't think it was reasonable. It's likely that he had that reasonable belief. So that gives you an idea of the extent to which tribunals are looking for anything to hang their hat on in coming to a view about likeliness. The main case is this Taplin case, which I'm not going to discuss in any great detail. But what it gives you is it shows you what the problem is with analysing legally a word like likely, because we really have two mechanisms, don't we, in the law for dealing with analysing a word like this. You either try and ascribe a percentage figure to it, and you could say 51%, but we know that's not right. Are you going to say 75% is what likely means? Well, it's not going to work in any case. In this case, Mr. Justice Sling said it's very unhelpful to paraphrase, and then decides to paraphrase by saying it doesn't mean possible and it doesn't mean probable. It means pretty good chance. So he's moved the law on very significantly by turning likely into pretty good chance.
So you're all clear then?
So we're all very clear about what that means. But actually, I think the what it means in practice, at least in my experience, is presumably the employment judiciary are people who have some experience, both in practice and on the bench, in looking quickly at cases and coming to an instinctive view about a case. And I think you're going to have a good shot at an interim relief application if, on getting the basic facts down, on a skim of the ET1, this feels to a judge like the sort of case that is going to be a winner. Leaving aside the detail, leaving aside the points that are going to come back. If the ET1, on reading it, sounds like it's going to be a winner, then great, you're in and fighting. If not, you're not. And that, I think, is in reality what the test is, even if we're told it means likely, it means pretty good chance. The Dandpat case gives a good example of why the courts think of it as a high test. And the reason it's a high test is because the pot of gold at the end of the rainbow is just so significant that on a very summary basis, the claimant is able to remain in employment, possibly not even have to do the work, and remain on all of his or her benefits. So the courts think of it as a high test. But as I say, I think in practice, is there an instinctive feeling that it's a good one? As I've hinted before, because the Sarfraz case is a case in which this went wrong, the pretty good chance likelihood test applies to everything. The employment status question is dealt with in this way. So that was a case, Hancock, in which the employer said, well, this only applies if you're an employee, and we think he's not an employee. So you've got to determine that question positively before you can go on to determine the interim relief application. Not a bit of it, says the court. You apply that likely test even to that preliminary question of status. Al-Qasimi is a case where a defence of illegality was raised, and again, that had to just be dealt with on the basis of the likely test. I suppose it has to be is the illegality defence such that it is not likely that the claimant is going to succeed? So it's the other side of the coin. Premature adjudication, not a problem I suffer from myself. It is but of course, what you're dealing with in a case like this is a summary assessment of the case right at the beginning, before any disclosure, before any sort of real detailed analysis by either party of the case. But the judge is required to express a view at that early stage. And what that means, of course, is that they will not be able to hear the case themselves later.
So back to me for the continuation order. Now, there is an inherent value, talking about the premature adjudication point, there is an inherent value in the fact you're going to get a judgment from an employment tribunal, which is going to say why a tribunal has either found that there is a pretty good prospect of success in your whistleblowing claim or there isn't. Clearly, if you get the finding that there is, it's going to be hugely valuable, and it's going to, one would have thought, at least stimulate settlement discussions. So when you've argued the points, you've identified the key issues, the tribunal has said, yes, I think you've got a pretty good prospect of success on your whistleblowing claim. So the tribunal, having done that, explains to the parties what powers it has and what orders it can make. And the first thing that it does is then invite the employer to reinstate or re-engage the employee on not less favourable terms. Now, I don't want to sound cynical, but I can't imagine that if you sack somebody and then they say it's because of whistleblowing, that there is any real likelihood that most employers will then say, oh, okay, tell you what then, please come back. Let's all hold hands around the campfire and be friends again. But in principle, that can happen. If the parties therefore agree, the tribunal makes an order to that effect. If there isn't agreement, the tribunal then, unless it considers that the claimant has unreasonably refused an offer of re-engagement, again, it could happen, but my suspicion is it's not going to, the tribunal makes an order for the continuation of employment compliant with section 130. And this is, quite frankly, a Willy Wonka golden ticket for a claimant, because it preserves pay and other benefits for the continuity of employment for the entirety of the litigation. Claimant doesn't have to do a hand's turn, but is paid as though they are at work and performing the role. And the important point is, as Mr. Justice Underhill referred to in DanPat, if you get this order and you eventually lose the litigation, you're not obliged to repay the sums that have been paid during its currency. Although I did the Al-Qasimi case not in the EAT or the Court of Appeal, but on remission. And one of the points was that sums had been paid under the continuation order and therefore ought to be repaid because they ought never to have been paid because the appeal had succeeded. So we entered into all sorts of exciting discussions about the tribunal's powers of set-off and in terms of the eventual remedy. But that's a story for another day, particularly when we've got longer than we currently have. Now, once the continuation order is in place, you can apply for an order for variation or revocation in circumstances where you can demonstrate that there's been a material change in circumstances. Recognise, if you are for a claimant, however, that the sums that you are paid are not taxable as an emolument of employment, but rather as a termination payment. So it's potentially important that if you get a continuation order and you then enter into discussions further down the line, which lead to a settlement, that the continuation order payments will eat into your £30,000 tax-free sum for the purposes of HMRC. And as I said, I've already made this point, you're not obliged to pay it back, unless, of course, the order were appealed. But in any other circumstance, the claimant is entitled to keep the money. So, practical tips. Graham's going to open up. He's for, as I say, forgive me, he's for the claimant, and I'm for the big bad respondent.
So, the first practical point: clients, claimants love the idea of winning Willy Wonka's golden ticket, of course. And we often have a tendency, don't we, to think what we must do is be aggressive and we must, quote, put pressure on the other side, etc.
Send a message.
Send a message, all of that sort of stuff. And that's great until you are drafting the application, you're in court 7 days later, and you find that actually you can't articulate why this is a case that is actually likely to succeed. And what you have done is an expensive charge of the Light Brigade, where an employment judge says, no, I don't think it's likely that you're going to win. You're not likely to win. And what greater comfort could you give to a respondent than rushing in like that? I think that the two big issues are invariably articulating the protected disclosure in your own mind first before putting pen to paper. There's whistleblowing and there's whistleblowing, and we all know that some protected disclosures are better than others. Make sure it's whistleblowing but not whistleblowing. Equally, causation is very often the issue, and sometimes a case that can look very good on paper, you know, I raise a protected disclosure at 10 o'clock and I'm sacked at 11 o'clock, superficially attractive. All a respondent needs to do is reveal the email that said they decided to dismiss you a month earlier for that all to unravel. So be critical, be self-critical of your position before rushing headlong towards those cannons. Do you want to say anything?
Just to endorse that point. So, for example, I was recently approached in terms of an interim relief application in circumstances where the focus had been very much on, look at all of these disclosures. It's financial services industry, the nature of the disclosures, they were obviously protected disclosures. And there was a superficial temporal connection between the fact or the timing of the disclosures and the dismissal. But there hadn't been any focus on causation. And question I simply said was, well, what was the mechanism of dismissal? Oh, well, he was made redundant. Okay. Was anyone else made redundant? Yeah, there were 3 persons made redundant in the redundancy exercise, which immediately is going to open up a huge causation difficulty, because it's going to be difficult. I should say those other 2 persons weren't said to have made protected disclosures. So there's got to be, you've got to really step back from the canvas and look at the entirety of the issues that you are likely to be required to prove, and ask yourself at each and every stage, do I have a pretty good prospect of success?
Now, you will never attend a Littleton talk in which you are not told you must instruct counsel as soon as you can.
And this one's not going to buck that trend, just to be clear.
It's true. It's true every time we say, but it's particularly true this time, and that's for 2 reasons. Of course, there are times when you, as solicitors, will have been with the client throughout the dispute that then dissolves into a dismissal, and we can bring an objectivity coming in at that last moment that there's a danger of missing sometimes. But the other point is there is an awful lot of work involved in getting an interim relief application from an idea into court, and it all has to be done very quickly. As Nick said, it's the closest thing we've got in the tribunal to a High Court injunction application. So I'd say it's a very good idea to get the team together as quickly as you can to get things moving. I think it's critical that the person who drafts the application is the person who drafts the ET1 and is the person who then articulates the application in tribunal, so that everything is at least clear in that person's mind, and that person's vision of the case is what's presented to the tribunal.
And effectively, I would endorse that from the perspective of the respondent, because if you're served with an interim relief application, you effectively you're going to be in front of an employment judge in 7 days' time. And in the same way, Graham's going to talk very shortly about how you need to focus the application. there needs to be a critical analysis of what are we as a respondent, what are we going to put in front of the tribunal? What evidence is it worth us disclosing now? Because there's always the question of, you don't want to show too much of your hand at the beginning, but equally you want to show enough of your hand to be able to satisfy a tribunal that there isn't a pretty good prospect of success. So again, early instruction, which is always a good idea, just to be clear, but early instruction in order to focus on what precisely you're going to want to muster in response.
I've mentioned the ET1. I think the ET1 is the most important document when it comes to an interim relief application. It must be a model of clarity in explaining what the protected disclosures are and why that protected disclosure gave rise to the dismissal. It is more like a skeleton than a pleading in these sorts of cases, because it needs to be crystal clear why you've got that pretty good chance. We, as I said at the beginning, this is going to be the first thing some employment judge sitting in a room somewhere on a sort of rainy 8 o'clock in the morning, waiting.
They're that early. Wow.
Waiting to decide on a summary basis this case, and they're going to read the ET1, and they are going to have that instinctive reaction. Yes, this feels like a winner. No, it does not feel like a winner. So the ET1 really is the moment, I think, the moment of truth. The worst thing you can do in an ET1, if you want to win on an interim relief application, is bog it down with the, we've all been involved in those cases where every single interaction between a claimant and a respondent gave rise to 20 protected disclosures, each of them protected disclosures for 20 different reasons. Bogging yourself down with that is the opposite of what you need to be doing. And a point that I raised there, because of the timing issues, you don't have to bring the full claim. If you also want to bring an ordinary unfair dismissal claim and a detriment claim and a 2P claim or whatever it is, you've got 3 months for that. But you've only got 7 days for the interim relief application. So you can carve it off and bring it another time. Of course, procedural time limits, etc., and you will have to early conciliate for that. But you can get the first salvo in early if you prefer to do it that way.
And as I said earlier, there's a big question for the respondent. Does it respond in terms of an ET3? It's an interim relief application. There's no requirement to do so. And it's rather like in responding to an interim injunction. Do you put evidence in on behalf of the defendant in the High Court proceedings? It's going to depend upon the strength of the case. But there's no harm in putting in what is in essence an interim response, saying, this early stage of the litigation, we haven't conducted full investigations, but here are the key points that the respondent is going to want to deploy. Or do you just leave it for a witness statement? Now, there's no right answer. It's going to depend on the particular circumstances and how bang to rights you may or may not be. But certainly it is worth thinking early about the extent to which you articulate your case. Choosing Graham's example, if you've got the email of which the claimant had no idea, demonstrating that you were planning to sack them a month before they raised the protected disclosure, I cannot think of any reason why you wouldn't want to be shouting from the rooftops about that.
I think everything we said about the ET1, I would say about the actual application itself. So I'm going to move on to our final point about the hearing itself. Nick's already talked about getting a delay. There are obvious reasons why a respondent might want a delay, but you need the special circumstances. I was involved in a case recently where the respondent was able to secure a delay because it was a school and it was half term. So call that a special circumstance. It was in that case. Obviously, the absence of an ET3 is not a special circumstance because it's almost par for the course in these sorts of cases. I have had fallings out with solicitors before in interim relief applications where they were very keen that every single relevant document was included in a bundle, and it was therefore going to run to 900 pages. If you have a 900-page bundle in an interim relief application, you're not going to win because it can't be that complicated if you're going to win after a 7-day interval. So don't do that. If there are really key documents in addition to the ET1, etc., then great. I had one recently where, in effect, the respondent had said, "Thank you for your protected disclosures. We're very offended by what you've said, and we don't think you can continue working here anymore." That we included in the bundle. You'll be surprised. But other than that, no. One of the points that Nick made earlier judges sometimes want to wimp out of these decisions because they're not used to having to deal with things in such a summary way, and they might feel a cavalier way. If you're for a claimant, you have to make them not wimp out and say, I've had it before where we made an application, we didn't win, but effectively we didn't win because the judge said, well, it's all too complicated. And we made an immediate reconsideration application to say, you're not allowed to wimp out. He then found against us, but still, we made him not wimp out.
At least you were right.
But at least I was right. And as I say, the overarching theme through all of this must be clarity, simplicity. It is obvious in this case why we must win.
And if you're for a respondent, you take everything Grahame said and adopt the exactly opposite approach. Because what you want to do is you want to make this as difficult and complicated and lengthy and labyrinthine as you possibly can. So, you know, if you're for a respondent, you'll be saying, well, actually, this 3,000-page FSA report is crucial to determining the real motivation. You just want to make. It's generally not a good approach to throw as much mud as you can in the hope that some of it will stick. But in an interim relief application, that very often will guide your approach, because you want to throw as many obstacles in the mind of the judge, knowing that the judge has to be satisfied that as regards each and every obstacle, there's a pretty good prospect of success. So if any of them are arguable, you put them before the judge, and then you want to put as many documents as you can. If you have Grahame's, oh, we got your whistleblowing, you can't now work for us, you may want to refer to a case called Kong. Grahame and I talk about that quite a bit, just to make it as difficult and as complicated as you can, to say to the judge, this is angel's fear to tread territory, don't be going there.
So, as we say, something that you might want to think about in cases, but think very carefully, don't get too excited about it. But this is a weapon in your arsenal if you want to go there.
And instruct Littleton early.
Yeah. So not premature at all. Let's have some coffee.
Thank you very much.